Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will talk about an often mentioned case decided by the High Court of Australia in 1951. I'm referring to the Australian Communist Party case. I am sure you have watched the videos about the characterization of laws that we have in this channel, right? These videos will be very important for you to understand some of the things that we will look at today. So if you have not yet watched them, click on the card above, watch them first and then come back to this video. Okay, let's go to the Communist Party case now, starting with the facts of the case. Do you remember that after World War II, we had a Cold War where the world was basically divided into two blocks. One was led by the Soviet Union with a communist worldview, and the other one by the United States of America with more of a classical liberal worldview. Well, it was in this context that the Commonwealth Parliament enacted a law called the Communist Party Dissolution Act from 1950. In the preamble to that act, the Commonwealth Parliament argued that the Communist Party was a violent revolutionary party that aimed at overthrowing the Australian system of government. They also said that the communists had spies that could jeopardize Australia's peace and welfare. One of the ways they would do that was through various strikes in vital industries that could compromise Australia's defense. So the act declared the Communist Party an unlawful association. It dissolved the party and forfeited its properties. And the act further declared the Communist Party as dangerous to the defense of the Commonwealth. The Australian Communist Party, together with some unions and individuals, sought a declaration that that act was invalid. The question before the High Court of Australia then was whether the Communist Party Dissolution Act was a law related to the defense of the Commonwealth, and as such, whether it fell within the scope of section 51(6) of the Australian Constitution, the defence power. The High Court was also invited to answer whether the recitals in the preamble to the Act were sufficient for the legislature to instantiate the effects coming out of the defence power. That is, could the legislature enact laws under section 51(6) according to some facts that the legislature themselves had established in the preamble to the Act? How did the High Court then decide this case? I will tell you, but first you have to click the like button and subscribe to our channel. Now, seriously, but before I give you the answer, I have to tell you a couple things about the defense power. One, you actually already know because you've been watching my previous videos. The defense power section 51(6) is a purposive power. The High Court, to analyze this, would need not necessarily to look at the content of the law, but analyze its purpose, its ends, the objectives of the legislation. This was clearly stated by Justice Dixon in a case called Stenhouse and Coleman from 1944, and was confirmed by Justice Fullagar in his Honour's opinion in this case. But that is one thing. The other is, what is the defence power about? Section 51(6) says that Parliament shall make laws with respect to the naval and military defence of the Commonwealth and of the several states, and the control of the forces to execute and maintain the laws of the Commonwealth. As early as 1916, the High Court had already decided that the expression naval and military were not supposed to limit the scope of the power. They were words of extension. They were illustrative of the purposes of the defense power and did not exhaust its content. So other things that are not necessarily related to the military can fall within the scope of the defense power of section 51. The idea is that this constitutional provision contains a sort of elastic power. The defense power varies according to the situation, and the variation will correspond to the nature, degree, and intensity of that particular state of affairs. If Australia is in the middle of a war, the scope of the power will increase. If in periods of peace, the power shrinks back. The extent of the defense power depends on the actual situation at hand. Lambert Mowens commented, the nature of the threat or hostilities will qualify the nature of the controls which may be imposed. Let me open a parenthesis here. I must say that this is an exception to what is otherwise considered the literal approach to interpreting the Constitution. Because when reading the defense power in section 51.6, the High Court's not only considering the text of the Constitution, but they are also considering some extrinsic factors, some things that are outside of the Constitution in order to interpret and characterize the defense power. So it is an exception to the major methods of constitutional interpretation adopted by the High Court. Justice Fulliger also said that since the defense power is a purposive power, it has two aspects. In its first aspect, section 51.6 authorizes the making of laws which have as their direct and immediate object the naval and military defense of the Commonwealth and of the several states. This power is clearly not confined to time of war. His Honour exemplified this first aspect of the defense power in conscription and training of military people, the acquisition of ships and ammunition, the construction of fortifications. That is, things that could still be done in time of peace, but still relate to the defense power of the Commonwealth. But the second aspect of the defense power, just as Fulliger said, has so far only been invoked and expounded in connection with an actual state of war in which Australia has been involved. So it relates to actual measures necessary to promote the security of Australia in a particular situation. Look at what His Honour said. In its secondary aspect, the power extends to an infinite variety of matters which could not be regarded in the normal conditions of national life as having any connections with the defense. Examples now familiar are the prices of goods and the rationing of goods, rents and the eviction of tenants, the transfer of interest in land, and the conditions of employment in industry generally. So this is the defense power. It has these two aspects. Now, in light of all of that, what was the decision of the High Court in the Australian Communist Party case? The majority of the High Court, 6-1, with Chief Justice Layton in dissent, decided that the Act was invalid. The Act was not shown to be a law for the defense of the Commonwealth in the peacetime context of the Act. Justice Dixon and McTiernan basically said that there was peace in Australia and that the Communist Party was not dangerous enough to justify the usage of the defense power in section 51.6. Justice Williams also said that Australia was at peace and that since the defense power waxes and wanes according to the circumstances, the Act should not be considered within the scope of the defense power in that case. Justice Fulliger, after explaining the two aspects of the defense power, said that no state of affairs existed that would justify the usage of the second aspect of the defense power in that particular circumstance. Justices Webb and Keto had different approaches, but they also agreed with the majority in that the Dissolution Act was invalid. Look, the High Court did not say that the Commonwealth Parliament did not have the power to eventually legislate about these matters. It said that the Parliament failed to prove that in those circumstances it was to exercise the defense power. And they went further, because by having that really long preamble explaining the reasons why the Communist Party was such a threat to Australia, what Parliament really wanted was to arrogate to itself the power to dictate when it could exercise the defense powers. Parliament wanted to determine when it could or not legislate about the defense of the Commonwealth. However, as Justice Fulliger said, Parliament could not do it, and he famously put it that way: a stream cannot rise higher than its source. Parliament could not just affirm certain facts in a preamble to an act and expect that that would justify the exercise of certain powers. No, the judiciary will analyze the facts and characterize the law according to an appropriate head of power in the Australian Constitution. So the High Court asserted that the validity of the law did not depend on the allegations made in the preamble to the Act. Justice McTiernan, to that effect, said that the recitals are in no way decisive of the questions whether the Act is valid or invalid. For that is a judicial question, which only the judicature has the power to decide finally and conclusively. The recitals are not judicial findings and do not bind the judicature on any question within its own exclusive province. All in all, the High Court said that the measures proposed by the Act were unjustifiable at the time. Since the defense power is a purposive power, we can say that there was an imbalance between the means, the dissolution of the party, and the ends that the legislation aimed at achieving. The conclusion, therefore, was that there was no appropriate head of power to support the dissolution of the Communist Party in that particular time. And neither could the affirmations made in the preamble to the Act support the exercise of the defense power to validate the Act. Okay, since you're here until the end, there are some things that I still wanted to tell you. This case was a fight of titans. Seriously. The Commonwealth had 3 lawyers that were later to become justices of the High Court. And on the Communist Party side, one of the lawyers was Doc Evatt, who had been a justice of the High Court and was now a member of Parliament. Evatt was also one of the responsibles for defeating Menzies in the proposed referendum to change the Australian Constitution in 1951 and include the possibility of Parliament to legislate about communists and communism when that became a threat to Australia. So there's plenty in this case that makes it one of the most important cases ever decided by the High Court. I hope you liked this video about this super important case in Australia's history. And I hope to see you again soon. Until then, ciao.